for that introduction. And I am aware that I'm the woman that's standing in between you and your lunch, and I promise that I'm going to make my presentation worth your while. But But nonetheless, I think my presentation really is a culmination of what everybody has said. And I think in particular, a lot of the points that Terence Corrigan made, I think I'll also be touching on that. And I think the importance of it really is just to amplify the message that right now, as South Africa stands, we have a constitution, we have Section 25 of the Constitution, which is perfectly capable of meeting the country's land reform requirements. So that said, the succinct message of my talk this morning is that there is no need to change the Constitution in order to effect effective land redistribution. So what I've done is look at Section 25 in its totality, and what I'm going to do is really break down the theoretical aspects of Section 25. So the important thing to understand about the current property clause is that back when during the CODESA days, it was actually the very last clause which the various parties agreed upon because of its highly contentious nature. And the interesting thing is that back then, the ANC did not want a property clause because their fear was that if the property clause is entrenched into the Constitution, then it would make land reform and land redistribution near impossible. So the final result of the Constitution is really a culmination of two positions, reflecting the two dominant schools of thought in the CODESA days. So the first part of the Constitution, which is Section 25, subsections 1 to 4, are really about the protection of existing property rights. And in that said, when I talk about the property clause protecting existing rights, it's really a negative protection. So it's a negative guarantee in the sense that the Constitution doesn't make it a right to own property. It simply says that if you have property, then no one can arbitrarily interfere with that property, and this includes either private individuals or the state. But if there is a sufficient degree of interference with that property, which rises to an expropriation, then you are entitled to compensation, just and equitable compensation, and it's a kind of compensation which is then calculated using certain factors, of which market value is but one of those factors. And the other factors are, and I see Dr. Anthea Jeffrey sitting over there, what she calls the discount factors. So these are factors such as the history of the property, the manner in which the property was acquired, the extent of direct state subsidies. So what we often hear in the media is this idea that because of a willing buyer, willing seller approach, land reform has become unaffordable because property owners are asking for market value. But the reality is that in terms of the Constitution, there is no requirement to abide by market value. Then I move on to the second part of the Constitution, which I call the transformative aspects of the Constitution. And in a nutshell, this sums up what the ANC wanted in the CODESA days. So sections 25.5 to 25.9 make reference to land reform, and this is where land reform comes in. And in terms of the Constitution, there are three tenets of land reform. So the first being land redistribution, and there's really no definition in terms of the Constitution. It's just a reference to land being, to individuals being able to access land on an equitable basis, but we understand that to mean land redistribution. And then the second aspect of land reform is land restitution. So land restitution simply refers to communities or individuals who are dispossessed of land on or after 19 June 1913 as a result of racially discriminatory laws. So in a nutshell, this really speaks to, and it does in a sense tie in with the presentation that Mr. Noluchungu spoke about in the morning, because that date is the date that coincides with the first major act which led to a lot of land dispossessions. And then the third aspect of land reform is that of tenure security. So tenure security is really mainly geared towards individuals who currently live on property but have insecure title. So this is where farm workers, for example, would come in, and there are a few laws that have been put in place in order to ensure tenure security. So, having presented what Section 25 looks like, I'm going to talk about how the courts have understood Section 25 to be. And in this part of my talk, I'm going to call it the schema of Section 25. So first of all, the protection of existing private property rights from unreasonable interference either by the state or from private individuals. So in that sense, the Constitution is quite clear in that private property is strongly protected. So, for example, even if one can, and in that sense, it's not just ownership which the property clause protects, but it protects a continuum of rights. So in that sense, the Constitution represents a difference from the common law in that the common law would give precedence to ownership, whereas the Constitution protects even rights which are weaker than the ultimate ownership. And the second part being that property rights are not understood in isolation, but they are understood in the context of societal considerations such as the public interest. And in this regard, I'm just going to make reference to, for example, the PI Act, which is the Major Eviction Act, which takes place in terms of Section 26 of the Constitution, which is the right to housing. So in that sense, whereas before, when it came to evicting tenants, for example, the only question before the courts would have been who has the stronger right, who is the owner of that particular piece of property. And if you can prove ownership, then it was quite easy to then grant an eviction order. Whereas now, because of the right to housing, the PI Act tries to balance the rights of, it tries to balance on the one hand ownership and on the other hand individuals who have lesser rights. So even though it is ultimately possible to obtain an eviction order, but due process has to be followed before that court order is granted. And the courts have to ask various questions. For example, how long has this individual been staying on this property? Are there any vulnerable people, like elderly people? Are there children, etc.? And importantly, this act ensures that municipalities should take reasonable steps to ensure that people get access to housing. So in that sense, it's quite clear that there is a societal aspect to the notion of property ownership. So in that sense, Section 25 isn't just about asking who is the owner, it's also about considering lesser rights within that property continuum. And a third aspect of Section 25 is that it creates a creative tension between individual and societal interests in the distribution of land and property. And the interesting thing is with Section 25 is that it uses the words public interest and also public purpose. So the public purpose is a much wider requirement, so a requirement which would benefit society at large. So for example, the building of roads, railway lines, dockyards, etc. So that would be the public purpose. Whereas the public interest comes in when we start talking about land reform. So in the sense that even if my neighbor's property is going to be expropriated, it doesn't benefit me individually, but it benefits the nation as a whole, and that is where the public interest requirement comes in. So in that sense, there's a delicate balancing act that's at play, but there's this obvious tension on the one hand between obviously the protection of existing rights, but also ensuring that more South Africans have access to those same rights. And, okay, that's a stray sentence, but in addition, so the interest isn't just in terms of the unilateral protection of individual property rights, but also the society at large. And ultimately, Section 25 entrenches and ensures that the state gives effect to land reform measures that serve the broad public. So again, it goes back to that notion of distinguishing between the public interest requirement and also the public purpose requirement. And in that sense, the property clause is very much a departure from the narrow conception of what property and ownership means at common law. So that said, having explained how the courts have interpreted Section 25 of the Constitution, I'm then going to focus on land reform. And so the first aspect of land reform being land redistribution, and at this point I think Terence very much spoke into the current problems affecting land redistribution, and I don't really intend to rehash what he's already said. But bottom line is, this is where the biggest problem lies with land reform. Firstly, there is no policy certainty simply because we don't have a singular piece of law which governs how exactly land redistribution is going to work out. So land reform is very much left to the political head. So in the sense that if we can trace the various policies governing land reform since 1998, there have been a lot of changes. And in the beginning, it appeared as if land redistribution was geared towards individuals who otherwise couldn't afford to engage with the free market. So, for example, individuals who were earning less than 1,500 could get subsidies from the state. But at the moment, the current policy that's in place is a policy where people aren't even being given title to land. So at the moment, there are about 20,000 farms which are on the market, which the state has expropriated and has paid compensation, but the state has identified so-called beneficiaries, but these beneficiaries do not have title to those properties. And of course, we all know the problems that go with the inability to prove that one is an owner of that particular property. So you have individuals who are, for all intents and purposes, the owners of these properties, but they cannot access capital in order to keep those farms going as a going concern. So that's really one of the biggest problems that's been associated with land redistribution. And of course, we wouldn't be the South African nation if we didn't talk about things like corruption and state capture. But because of this policy uncertainty, because of the fact that the state hasn't been able to ask itself who exactly is it seeking to benefit in terms of land redistribution, in the sense that is it seeking to ensure that there's a new class of commercial farmers, is it seeking to simply give people on the basis of their skin color land. So because of that, it has created a lot of corruption, and there have been quite a few instances where politically connected people who would otherwise be able to afford to engage the markets out of their own free will have been simply given land by the state. And so, yes, so tenants of the state, so there's no full ownership, and also the fact that there's very little post-settlement support. So in the sense that the state simply gives individuals land and that's it. And these are the same individuals who can't raise capital because they can't prove that they're the owners of those particular farms. And in general, when it comes to land reform, there's really lots of chops and changes when it comes to policy. So there's a lot of uncertainty governing land reform and land redistribution. And importantly, the manner in which land redistribution is effected is essentially through the Expropriation Act of 1975, which is still the Expropriation Act which governs how expropriations are conducted. And that's problematic for a lot of reasons, and the most important reason being that the Expropriation Act predates the Constitution. So in many ways, it doesn't reflect the values of the Constitution. So, for example, the Expropriation Act says that you have to compensate at market value, and then market value is defined as that which a willing buyer would pay a willing seller, which, if you think about it, is already a bit ironic because an expropriation is a forced sale. So because it's a forced sale, one shouldn't really be thinking about one's free will in that particular instance. And also, the Expropriation Act only talks about expropriation in the public purpose. It doesn't consider the public interest. And the public interest is a much wider concept than the term public purpose. And also, in general, and this is the most highly problematic aspect of the Expropriation Act, that the Expropriation Act recognizes ownership, first of all, and only certain rights which have been registered. So this means that for the vast majority of South Africans, I think the statistics say there about 60% of South Africans live on land which they consider to be the owners, but they just can't prove that they're the owners in that they don't have title. So it means that for those individuals, if they are expropriated in terms of the Expropriation Act, they're not regarded as owners, therefore they're not entitled to compensation. So again, it reinforces a certain level of vulnerability. And moving on to land restitution. So the problems of land restitution have also been pointed out. So the fact that land restitution is taking place at a very slow pace, and the current statistics say that for claims that were lodged in 1998, it's going to take another 35 years to settle those claims, and for claims which were lodged after 2014, it's going to take 145 years to settle all of those claims. Apart from the fact that there's also been a lot of uncertainty regarding land which is given post-restitution, in the sense that the state has from time to time been known to impose partners on communities and has forced communities to form communal property associations before they receive land. And the third aspect of land reform is that of tenure security. And I think with regard to tenure security, there have also been quite a few speakers who've mentioned some of the problems associated with tenure security. So, for example, we have the informal protection of, or the interim protection of informal land rights act, which is an act which was supposed to have been given a permanency, but it's keeps on being renewed every year, because it was really an act which was supposed to be an interim act just for that particular year. And also when it comes to farm workers, for example, we do still see a lot of farm evictions. And in fact, statistics suggest that there have been more farm evictions that have taken place in terms of the ESTA, which is the act that governs farm evictions, than before this act ever came into place. And yet the Constitution does make it clear that Parliament has to create a law which ensures that there's tenure security, and this hasn't happened. So in that sense, Parliament at the moment is very much in breach of its constitutional obligations. So that said, what are the solutions? Obviously, I do not favor the amendment to the Constitution, because, as I've pointed out, the problems that are associated with land reforms, even if the Constitution was to be amended, if we don't take care of those very basic problems, these problems are simply going to be replicated. So to begin with, to enact a new expropriation act, which is in line with the Constitution, and also just to provide legislative certainty as to how exactly land redistribution is going to take place. So who exactly are we seeking to empower? What is the purpose of land redistribution? Is it to create livelihoods? Is it to ensure a new class of black peasant farmers, for example? These are details which are simply not there. And also enacting a new piece of legislation in line with Section 25(6) of the Constitution, just to ensure that there is tenure security. Because at the moment, and I think statistics seem to suggest that there is even greater tenure security right now than there was before 1994, especially if you consider some of the aspects that Terry spoke about, for example, the manner in which Ingonyama Trust conducts itself in KZN, etc. It does feed into tenure insecurity. So, and also just putting money into land reform. My next slide is really going to show the fact that this is what's been happening with land transfer through redistribution, the fact that there really isn't any political will. And the interesting thing is that you can see that the pinnacle of land reform coincides with former President Jacob Zuma's tenure as head of state. So I think that in its own speaks to a lot of really corruption and governance issues which reflected the former president. And I think land reform and land redistribution is an area which also, like state-owned entities, etc., is an area which was also affected by the previous regime. So that in a nutshell is my presentation. And the point being that we don't need to amend the Constitution. The problems are known, they've been identified. The Constitution is adequate in terms of addressing the very pressing needs of land redistribution. Thank you.